Thank you, everybody. And this is the subject Muslim law, which is first year, second semester course. Under this Muslim law, today our online class is on divorce. In Arabic, we will say divorce, talaq. Talaq is the Arabic word, and divorce is the English equivalent. And sometimes we use synonymously divorce and talaq. But generally, when you say divorce, the divorce can be made or given by the resolution of Muslim Marriage Act, and the talaq is purely based on personal law. And now we see what are the things should be covered under this chapter or unit. Then first we'll do introduction. Then we'll see the classification of dissolution of marriage. That is a kind of kinds of divorce, Dissolution of Muslim Marriage Act 1939, Talaq-Nama, Talaq made during the death illness, the legal effect of Talaq, that is the divorce, and the last part is conclusion. These are the things that we will cover it there. Let me see that the Talaq under the Muslim law, or we can say the divorce under the Muslim law. Introduction is concerned. For understanding the method of dissolution of marriage, let us first see what is marriage under Muslim law, because the only essential for a divorce under Muslim law is marriage. If there is no valid marriage, there is no question of divorce. Hence, first we will see what is the valid marriage. The dissolution of marriage is known as divorce according to the Dissolution of Muslim Marriage Act 1939, and talaq as per the personal law of Muslims, as I said in earlier words. We use these two terms interchangeably now and then in our class or lecture. Talaq is the Arabic word which means freeing or undoing the knot. I repeat, talaq is the Arabic word which means freeing, F-R-E-E-I-N-G, or undoing the knot. Here knot means K-N-O-T, knot. Under Muslim law, marriage is a contractual relationship between the two parties. All the essentials that are required for a contract are present under the Muslim marriage. There is an offer, acceptance, consent, consideration, the capacity of the parties, etc. The purpose of such a form of marriage are legalizing the sexual intercourse for the procreation of children. In the case of Shoharat Singh versus Jafri Begum, the Privy Council held that marriage under Muslim law is a religious ceremony. Under Islam, marriage is recognized as a basis of society. Marriage is an institution which leads to upliftment of man and is also a means for the continuance of the human race. Divorce is the end of such a marital relationship. As under Muslim law, there are two modes given for the dissolution of marriage. That one way is divorce or the other one is talaq. The Arabic word for divorce is talaq, which means freeing or undoing the knot, which I already discussed. In daily life, these two terms are alternately used, but under Muslim law, if a person seeks divorce, he will be governed by the provisions of the Dissolution of Marriage, Muslim Marriage Act 1939, whereas talaq proceedings are governed by the Muslim personal law. That means this divorce, there will be a legal divorce, there will be a legal remedy and there will be extrajudicial remedies. And where the extrajudicial remedies are concerned, and we will say it is in the form of talaq, and the legal remedies are concerned, and we will see it is in the form of divorce. That is, generally it will be decided, it will be classified in some of the book like that, judicial remedies and extrajudicial remedies, or judicial and extrajudicial solutions. Now we will come to the matter, how the classification of dissolution of marriage. And if you see this chart, first the classification of dissolution of marriage is divided into two, by divorce and by the death of the party to the marriage. Either by the death of the party to the marriage, then divorce would be there, or by the taking the divorce also, that is the dissolution of marriage is occurred. When it comes to the divorce, again we will see four divisions. Number one, by husband. Number two, by wife. Number three, by mutual consent. Number four, by judicial decree under the Dissolution of Muslim Marriage Act 1939. Under the same act, that is the Dissolution of Muslim Marriage Act 1939, there we will discuss Leon as well as the first, these two terminologies. And when you come to the matter of the husband is concerned, then husband, by husband, a talaq, ila, jihar, these are the three comes under the by husband, where the divorce would be taken. And by wife, divorce is talaq-tafwiz, or we can say talaq-tawiz, in other words. And by the third one, by mutual consent, again there are two types, that is one is khula and mubarak. And the fourth one is by judicial decree under the Dissolution of Muslim Marriage Act 1939, and we will find those provisions as well as the in section 2, and we will see the Leon as well as the first also under that caption. When you come to the by husband, the one is talaq. Again, talaq is divided into two. Number one, talaqul sunnah. Number two, talaqul biddat. Again, talaqul sunnah is bifurcated. Number one is ahsan, talaqul ahsan, and talaqul hasan. Ahsan spelling Ahsan, and the second one is talaqul hasan, Hasan. And we will see when you go in detail in further. Talaqul biddat, that is the second one under talaq. It is divided again into two. One is the written talaq and the second one is triple talaq. As we know, the triple talaq is unconstitutional now, as the Supreme Court has given the verdict, a judgment, which is triple talaq is against the Article 14 of the Indian Constitution. Now let us see one by one. By husband, first we see by mutual consent, by wife, and by the Dissolution of Muslim Marriage Act. Let us see first by husband. There are four modes of available before a husband for dissolving the tie of marriage. That number one is talaqul sunnah. This form of talaq is effective in accordance with the tradition established by the Prophet. It is further divided into two parts, and one is talaqul ahsan, Ahsan, that is talaqul ahsan, and the talaqul ahsan, that ahsan talaq consists of a single pronouncement of divorce made in the period of tuhr. Here tuhr means purity period. The purity between the two menstruations called tuhr, T-U-H-R, tuhr. Now pronounce the way that you want, but the spelling is T-U-H-R. And or any time, if the wife is free from menstruation followed by abstinence from sexual intercourse during the period of iddat, the requirement that the pronouncement be made during a period of tuhr applies only to oral divorce and does not apply to talaq in writing. Similarly, this requirement is not applicable when the wife has passed the age of menstruation or the parties have been away from each other for a long time, or when the marriage has not been consummated. The advantage of this form is that divorce can be revoked at any time before the completion of the period of iddat. Thus, hasty, thoughtlessness divorce can be prevented. The revocation may be effected expressly or impliedly. And it is known as the best form of talaq. Yes, I repeat, it is known as the best form of talaq as the name clarifies the same. The procedure followed by the husband is as follows. And number one, he has to make a pronouncement of divorce in a single sentence. Such pronouncement must be made in purity state, that is, when a woman is free from her menstrual cycle. Number two, the husband must not indulge in any form of sexual intercourse during the iddat period, that is the tuhr period, the period of chastity a woman Muslim is bound to observe after the dissolution of marriage, either by the death of her husband or by divorce. And if he does so, then it will be considered as implied revocation of talaq. It is pertinent to note that once iddat period has expired, the divorce becomes irrevocable. The third point is, when the partners have not consummated, that is talaq al-ahsan can be pronounced if the wife is in her menstruation. That is the points where Talaqul Ahsan will be applicable. That is the most appropriate form, the best form. Then we will see the second one, Talaqul Hasan, Hasan. Talaqul Ahsan, Hasan, that is the approved form. In Arabic, Hasan means good. While Hasan means very good, Ahsan means very good, Hasan means good. This kind of talaq is also regarded to be the proper and approved form. In this form also there is a provision for a revocation, but is not the best mode because evil words of talaq are to be pronounced 3 times in the successive tuhurs. This is also called of talaq al-sunnat, but considered less approved than talaq al-ahsan. In this form, the husband is required to pronounce the formula of talaq, the utterance of the words I divorce thee, and 3 times during the 3 successive tuhurs. If the wife has crossed the age of menstruation, then the pronouncement of talaq may be made after an interval of 30 days between the successive pronouncements. It is therefore a divorce upon a divorce, where the first and second pronouncement are revoked and followed by the third, only talaq becomes irrevocable. It is necessary that no intercourse should have taken place during the period of purity in which the pronouncement has been made. For instance, when the wife is in tuhur without having intercourse with the husband pronounced talaq, this is the first talaq. Then he revokes it by words or by intercourse. Again, when she is in tuhur and before intercourse, the husband pronounced talaq, this is the second pronouncement. Husband again revokes it. Again, when the wife enters the third period of purity and before any intercourse takes place, husband makes a pronouncement of divorce, and this is the third pronouncement. The moment of the husband utters the third pronouncement, the marriage stands dissolved irrevocably. In short, Arabic meaning of the Hasan is good, I already told. Therefore, divorce pronounces through Hasan mode is good, but lesser word than the ones pronounced in Ahsan, A-H-S-A, and the first one. Husband has to make 3 successive pronouncements for divorce in Hasan. In the case of menstruation of wife, such 3 pronouncements should be made in 3 consecutive tuhurs, that is the state of purity. In the case of non-menstruating wife, pronouncement should be made at 3 successive intervals of 30 days. No sexual intercourse should take place during these periods of 3 pronouncement. If such an act takes place, then the process of divorce will be revoked. Talaq Hasan becomes irrevocable on the third pronouncement irrespective of that period. Then the second one, which is under talaq, is called talaqul biddat. This form of talaq is introduced by ummayas in order to escape from the strictness of law. This is a sinful form of talaq and it is recognized among the Hanafis. Sunni law recognizes this mode of talaq, though recognized as a sinful by the two, whereas Shia and Maliki don't recognize this mode. 3 pronouncements made in a single tuhur, either in a single sentence or in a separate sentence, talaq, 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 or I divorce thee, I divorce thee, I divorce thee, that is enough. Single pronouncement clearly indicates an intention to dissolve a marriage and makes irrevocable. It is usually pronounced as I divorce thee irrevocably. Partners separated through the triple talaq can't remarry without the formality of the one marrying another man and getting divorced from him. This process is called nikah halal. I repeat, nikah halal, where partners separated through the triple talaq can't remarry without the formality of the woman marrying another man and getting divorced from him after the consummation, and this process is called nikah halal. In the most recent judgment, Shayara Bano versus Union of India and others, Supreme Court of India declared that the practice of triple talaq is unconstitutional, as this form of talaq is violation of the fundamental right provided under Article 14 of the Constitution of India, as I made it clear in my early class. Next, vow of continence. Besides talaq, a Muslim husband can repudiate his marriage by 2 other modes. These are ila and zihar. Again, we are discussing only the husband side. From the husband side, husband says number 1 is talaq, number 2 ila, number 2 ila, number 3 is jihar. And we completed regarding talaq's concern, which are again divided into two forms, and talaqul sunnat and talaqul biddat. And talaqul sunnat is divided into two again, talaqul hasan, and regarding talaqul biddat, we'll see it. We saw that it is also sinful and it is unconstitutional. And when it comes to the part of it, ila, that is a vow of continence. Besides talaq, a Muslim husband can repudiate his marriage by two other modes that are ila and jihar. They are called constructive divorce. In ila, I-L-A, ila, the husband takes the oath not to have sexual intercourse with his wife. Followed by this oath, there is no consummation for a period of 4 months. After the expiry of the 4 months, the marriage dissolves irrevocably. But if the husband resumes cohabitation within 4 months, ila is cancelled and the marriage does not dissolve. Under Itna Sharia Shia school, ila does not operate as divorce without order of the court of law. After the expiry of the 4th month, the wife is simply entitled for a judicial divorce. If there is no cohabitation, even after the expiry of 4 months, the wife may file a suit for restitution of conjugal rights against the husband. Where a wife hurts the feeling of her husband with her behavior and the husband hits back an allegation of infidelity against her, then what the husband says in response to the bad behavior of the wife can't be used by the wife as a false charge of adultery, and no divorce is to be granted under Leon. This was held in the case of Noor Jahan versus Khazim Ali by the Calcutta court. When you come to the zihar, injurious assimilation, a husband must be of sound mind and above the age of 18 years to be eligible to use this mode of dissolution of marriage. If he compares his wife to his mother or any of the female within prohibited degrees, the wife has a right to refuse to have sexual intercourse with him. Such refusal can be accepted until he has expiated himself from the penance prescribed by law. It can reconcile by way of fasting for the 2 months, or feeding 60 persons, or releasing one slave, or she may be applied to the court for an order requiring him either to perform the penance or to pronounce a regular talaq. Muta marriage, practiced among Shias, which admits no other sort of divorce, may be dissolved by jihar. Such form of divorce is no longer in use anymore. Talaq by wife, that is the second part, where we will say how talaq from the side of the wife. Divorce given by wife under the husband's delegated power, that is called talaq-e-tafiz. Talaq, T-A-L-A-Q hyphen E hyphen T-A-F-W-W-E-Z. Here, talaq-e-tafiz, F is silent. This is the only way through which a woman can give divorce to his husband. However, such power to give divorce needs to be delegated by the husband only. It is form of an agreement made either before or after marriage, providing that wife will be privileged to get separated from her husband via divorce under the specified condition as: in the case of husband marries a second wife, number 2, the husband is unable to maintain her for a specified period of time, any other condition that must not be opposed to public policy. In the condition agreed in the agreement by the husband as well practiced by him, then the wife, without any prejudicial to law, can dissolve her marital ties. The fact that husband delegates the power to the wife does not dispose him of his right to pronounce talaq. In M.D. Khan versus Shahmai, 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 under a prenuptial agreement, a husband who was a Khana Damad undertook to pay a certain amount of marriage expenses incurred by the father-in-law in the event of his leaving the house, and conferred a power to pronounce divorce on his wife. The husband left his father-in-law house without paying the amount. The wife exercised the right and divorced herself. It was held that it was a valid divorce in the exercise of the power delegated to her. Delegation of power may be made even in the post-marriage agreements. Thus, where under an agreement it is stipulated that in the event of the husband failing to pay her maintenance or taking a second wife, the will have a right of pronouncing divorce on herself, such an agreement is valid, and such conditions are reasonable and not against the public policy. It should be noted that even in the event of contingency, whether or not the power is to be exercised depend upon the wife. She may choose to exercise it or she may not. The happening of the event of contingency does not result in automatic divorce. Now, the third point is divorce by mutual consent. Although the practice of giving divorce by mutual consent was not recognized in the Muslim law, it was only available to the Muslim women after the enactment of Dissolution of Muslim Marriage Act 1939. That is, it is recognized. Number one, khula, Khula. The literal meaning of khula is to lay down before the law. The husband lays down his right over his wife. It signifies an arrangement entered into to dissolve the connubial connections in lieu of the compensation paid by the wife to her husband out of her property. Everything that can be given as a dower. Khula is a divorce with a mutual consent at the instance of the wife in which she agrees to give some consideration to her husband. It is basically a redemption of the contract of marriage. Essential for khula. Number one, there must be an offer from the wife's side. Number two, offer must be accepted by the husband with the consideration for it. Number 3, observance of the iddat period is necessary. Under Shia law, husband cannot revoke divorce once accepted where the wife has been given the power to reclaim the consideration during the iddat period. After the expiry of the 4th month, the wife has the following rights. Number 1, she may go to the court to get a degree of judicial divorce. Number 2, she may ask the court to grant a degree of restoration of conjugal rights. Where the husband wants to revoke jihar by resuming a cohabitation within the said period, the wife cannot seek judicial divorce. It can be revoked if, number 1, if the husband observes fast for a period of 2 months, or if he provides food at least 60 people, or he frees a slave, and this we already mentioned earlier. Now come to, according to the Shia law, jihar must be performed in the presence of 2 witnesses. I repeat, according to Shia law, jihar, Z-I-H-A-R, must be performed in the presence of the 2 witnesses. Next comes to the mubarat, M-U-B-A-R-A-T, mubarat, and it comes under the mutual consent. It signifies a mutual discharge from the marital tie. The most essential element is that mutual consent of both the parties is required in regards to the dissolution of marriage. In this mode of divorce, number 1, offer can be made from either of the side. Number 2, acceptance of the offer makes a divorce irrevocable. Number 3, iddat is necessary. Under Shia law, parties can dissolve their marriage if it is not possible for them to continue their marriage by way of mubarat. The last mode mentioned in the above table of the dissolution marriage is by way of judicial separation. That is Dissolution of Marriage Act 1939. Further, these are the 2 ways where one can get the divorce, that is li'an. And the li'an can simply be described as the wrong charge of adultery on wife by her husband. Whenever a husband imposes a false adultery charges on his wife, then a wife can sue him and can also obtain a divorce on the same ground under the Act for filing a regular suit for dissolving of marriage. In case of Zafar Hussain versus Ummat-ur-Rahman, Allahabad High Court held that a wife under Muslim law is entitled to file a suit against her husband for dissolution of marriage and can obtain decree on the ground that she was falsely charged with the adultery by him. What are the essentials for li'an? A husband must be adult and sane. Number 2, he charges his wife of adultery. Number 3, such charge must be false. Number 4, false charges don't ipso facto, by the fact itself, dissolve the marriage. It just provides a ground to the wife to move to the court to dissolve the marriage. And the next point is marriage will continue under the degree of the dissolution of marriage is passed by the court. And the last but one is judicial separation via mode of li'an is irrevocable. And the last point is this mode is applicable only to the sahih marriage, not on fasid ones. I repeat, the last point, this mode is applicable only to the sahih marriage, that is a valid marriage, not on fasid ones, that is called irregular marriages. Retraction can be made by the husband before the end of the trial, admitting that he made the charges of adultery against her wife and such charges was false. This retraction can be made and at that time the divorce cannot be granted. Then under it will come fusk, which is the point under the dissolution of marriage. We'll see fusk means F-A-S-K-H. Quran says that husband and wife are duty bound to respect each other and treat each other respectfully and above all lawful orders of each other. If both of them find that they can't live as a husband and wife further, they can approach Hazi, who, after careful examination, may terminate their marriage. That is the way the first, it is also a mutual consent in one way, in another way, but after the passing of the Act of Dissolution of Muslim Marriage Act, we know that this first is recognized. When you come to the section 2 of the Dissolution of Marriage Act 1939, states 9 grounds on which a Muslim wife can obtain a degree of divorce. I repeat, section 2 of the Dissolution of Muslim Marriage Act 1939 states as 9 grounds on which a Muslim wife can obtain a degree of divorce. Absence of husband and whereabouts of the husband are not known from the past 4 years. Dissolution of marriage decree on this ground will take effect after 6 months from the date of such decree is passed. And during that period, if the husband appears in person through an authorized agent, court, if satisfied, from same may set aside the said decree. And there are at least some of the points are given under it. Then the one point is failure to maintain under this Dissolution of Muslim Marriage Act under section. And if a husband fails to provide a maintenance to his wife for 2 years, there is no defense available before the husband on the ground of poverty, failing health or unemployment. That is also a good ground. And the imprisonment for your husband, if the husband is imprisoned for 7 years or more, that is also another ground. Then another ground is, that is a third ground, we can say, failure to perform the marital duties if without any reasonable cause the husband is unable to perform his marital obligation for 3 years, and it is also a good ground for the dissolution of marriage. Then comes another ground is impotency of husband. Husband was impotent at the time of the marriage and continues to be so. If the husband within 1 year from the date of the order obtained by wife for dissolution of marriage on the ground of impotency on application satisfy the court that he ceased to be impotent, if the husband satisfy the court, then no decree shall be passed on this ground. Then comes insanity, leprosy or venereal diseases. If the husband is insane or suffering from leprosy or any venereal diseases from a period of 2 years, judicial divorce by wife can be claimed on the same ground. And I believe this insanity, leprosy and venereal diseases, and this is, I believe it is repealed by the Amendment Act's later part. Comes to the repudiation of the marriage by wife. If a girl is married before the age of 15 years by her father or guardian, then under the Muslim law, she has been provided with the right to repudiate such marriage after attaining the age of 18 years, provided that marriage is not consummated. She is entitled to a degree of divorce for the same. And grounds for dissolution are recognized with Muhammad law. And the earlier grounds which is recognized with the dissolution of Muslim women's marriage, Muslim women Dissolution of Muslim Marriage Act 1939, and these are the grounds for dissolution of recognized by the Mohammedan law. Wife is also entitled to obtain the divorce on the ground recognized valid under the law. Cruelty by the husband. If the husband treats his wife with a cruelty, then she can approach the court, can claim for the degree of judicial separation on the same ground. Some of the ways through which grounds for cruelty could be claimed as follows. Number 1, physical assault. Number 2, making a defamatory statement affecting her reputation. Number 3, forces her to lead an immoral life. Number 4, obstructing her from practicing her religion. And number 5, husband having more than one wife and does not treat them equally. In Said Ziauddin versus Parvez Sultana was a science graduate and she wanted to take admission in a college for medical studies. She needed money for her studies. Sayyid Ziauddin promised to give her money provided she married him. She did it. Later, she filed for divorce for non-fulfillment of promise on the part of the husband. The court granted her divorce on the ground of cruelty. Thus, we see the court's attitude for attributing the wider meaning to the expression cruelty. In Zubaydah Begum versus Sardar Shah, a case that is from Lahore High Court, The husband sold the ornament of the wife with her consent. It was submitted that the husband conduct does not amount to cruelty. Now we will see what is Talaq-Nama. 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 Talqnama. Talaq-Nama. Like Wakalat-Nama. We will see Talaq-Nama is a talaq given in the written form. Talaq-Nama can be provided in the absence of wife, and also there is no necessity to be signed in the presence of the Qazi or wife's father. Number 1. Husband has to execute a proper deed. Number 2. A deed must contain the name of the woman whom he has divorced and his name. Points to be considered for a valid talaq. Number 1. Talaq pronounced under intoxication is not recognized valid under the Muslim law. For a valid talaq, intention is not an essential element. And third, husband may give talaq by mere words without any talaq-nama or deed. Talaq made during the death illness. Number 1. An ailing Muslim, generally men, have been given the power to pronounce the talaq just to prevent his right of inheritance moving to his wife after his death. Number 2. If the man pronounces irrevocable talaq in death illness and dies before the expiry of the iddat period, the wife is entitled to claim her share. Number 3. In case the husband dies after the expiry of the iddat period, then there is no right of inheritance. Then we will see what are the legal effects of divorce. If the legal effect of the divorce goes like this. Number 1. Mutual right of inheritance ceases. And number 2. Cohabitation becomes illegal and children born after such intercourse will be illegitimate. Number 3. Dower becomes immediately payable. Number 4. Parties can contract another marriage. And number 5. Wife is entitled to maintain during the death period. And we will see the conclusion part. Then after reading through that, after the 2017 judgments roughly of the Supreme Court held and declared triple talaq unconstitutional. Under Muslim law, both husband and wife are given equal right to dissolve their marital relationship. When two people enter into marital relationship, they may not know each other so well as they got to know each other after living together. After that, if there is no compatibility between the two, living apart is the best choice to be made. But relation may spoil in life of both the individual, and under Muslim law, talaq is an ancient practice and is not recognized as a sinful, and it is a last resort, we can say. By this, I end my online lecture. Thank you for your patient listening on my online lecture, online class. Thank you very much once again. Goodbye.